Lordship, there is a judgment. Just wait.
You'll have to wait till the matter is called. 2019 matters we are not adjourning.
May it please your Lordship. Lordship, in item number 47, we have circulated adjournment petition yesterday. This matter may come up after vacation.
47, 26 matter. Okay. When do you want?
Oh, for after vacation.
What is represented on the prayer made by learned counsel for the petitioner. The matter is adjourned today. Next matter is prayed for list after answering the vacation.
Deeply applied.
May I please, your Lordship? Item number 5, your Lordship.
You have to wait.
My Lord, M. Devi, she requested on telephone, your Lordship.
No, that's okay, but unless we look at the records, 2019 matter, we are not adjourning.
My Lord, she, due to some personal difficulty,
Okay,
and
we'll take a note, but we'll, unless we look at the record, we are not passing any adjournment in
My-
2019.
I'll be there. Obliged.
May it please
You
the
will not be
Lordship.
there, but we'll have to look into the
My
record.
Lord, she,
Even if you are not there, we'll have to look into the
my
records.
Lord,
We'll
my
not,
Lord, she said due to some personal difficulty, she went out.
okay, we'll not mark you absent, but
My Lord.
we'll have to look at the record.
My-
Lordship, may I pray for listing of a matter in motion column, my Lord. Can it be on Monday?
Give it to the proconsul.
Oblige, your Lordship.
Thanks, my lord. I have to mention for listing, my lord.
Give it to the proconsul.
Daily list item 1 for motion. Item 1.
Ms. Verma, last time Mr. Sharma produced, no, I think you produced a report showing that the petitioner has expired on 16/10/25.
Yes, Doctor.
After that, we close the matter. If any other relatives are proceeded with, then they'll be entitled.
Earlier, I produced some damage. It is from Lakshmipur, madam.
None appears on behalf of the petitioner on call. Our so and so for the respondents are present. Next. Next. The petitioner was also absent when the matter was previously listed on 7/12/2025, 19/1/2026, and 22/2026. Power. When the matter was listed on 22/2026. The learned standing counsel for the FT and border matters has had produced a copy of death certificate disclosing that the petitioner Bakuli Devnar had expired on 16/10/2025. So the forwarding letter dated 19/2/2026 and enclosures dated have already been made a part of record. Next paragraph. Mr. P. Sharma Lanet, additional senior government advocate, had produced a copy of letter dated 7/3/2026, bearing memo number issued by the additional deputy commissioner, comma, no, not comma, cum, ADRCR, comma, NRC, comma, Lakhimpur, comma, North Lakhimpur, had stated that after examination of the available records pertaining to citizenship certificate dated 3/5/1960, purportedly issued in favor of Shri Vishwambar, Viswambar, Vishwambar Devnath. The original record of the certificate is not available in the office of the district commissioner, Lakhimpur. However, it has been disclosed that the certificate was signed by sub deputy collector from Tinsukia. And that the present day Lakhimpur district was administratively carved out of the erstwhile larger Dibrugarh district on 2/10/1971. Thus, the original record of the citizenship certificate dated 3/5/1960 has not yet been traced out. Next, be that as it may, as the petitioner Bakuli Devnath has already expired on 16/10/2025, and no application has been made for implementing any family member, this writ petition stands dismissed on being abated. On abatement, not being abatement. Abatement. Next, brother. Next. Dismissal of this writ petition shall not be a bar for the competent authority to make inquiry against any other family member. Next up. This writ petition stands dismissed on being abated. Next, the registry shall send back the record back to the learned tribunal along with a copy of the order we made a part of the court. All right.
Item 2.
So that. So Sharma produced the record, made a part of it.
May I please, your lordships? My lord, before starting my argument,
Yes.
I enjoy your lordship's kind attention to the notice issued by the tribunal, page 38.
Yes.
The notice has been issued alleging that I am the foreigner of 1/1/66 to 25/3/71, that is stream. But the order, improvement order, which is page 43, abortive portion 50 and 51.
Yes.
50, can you see? In view of the above findings, this tribunal is the opinion that the OP is a foreigner, illegal migrant, had entered India on or after 25th March 1971, in exercise of power conferred under section so-and-so, the OP, namely Hasu Ali, son of so-and-so, of village so-and-so under so-and-so PS district Dorong, Assam, to be taken into immediate custody and be kept as internee. So the order says that I am an illegal migrant, but the notice says that I am the foreigner of 1166 to 25,371. So whether this order on this count may be declared as illegal, and as per the notice has been issued, I may be given that benefit. I shall register my name. In 10 years, I would be deprived from getting or casting votes.
Make your submission also on merit. We'll decide that issue also, but we'll also hear on merit.
On merit, my lord, there are another important event has happened in this case, page 40 candidacy. 40.
Yes.
The learned tribunal did not allow me, not only me, but various persons who are the proceeding of this type of cases to allow evidence, to adduce evidence that was not allowed. And the matter was highly protested by the lawyers at Mongoldi. And it is said that they came to the Honorable High Court, but High Court did not take any action. So matter went up to Supreme Court, and Supreme Court accepted the PIL. So I am reading that page 40, Proceedings News, Mongoldi for July.
No, newspaper we can't believe. You'll have to show us the SLP, the order of the SLP admitting it.
So
Because if it is there in SLP, it is available in public domain. If you put the numbers, you'll get it.
so that is there, but this matter went to the Supreme Court. Supreme Court has admitted, and it is the allegation that the learned member 1 and 4 of Dorong district did not allow the proceedings to adduce their evidences. So in that regard, I am reading the middle portion of page 40. As a part of it, the association had submitted a memorandum before the All Assam Lawyers Association, the Chief Justice of Gauhati High Court, the Chief Justice of India, and the Government of Assam to take legal action against these two members of the Foreigners Tribunal.
You see, Mr. Mahmood, this doesn't help you. In your case, you have not shown us the order sheet. You have not shown us anything that you have filed an application.
Now,
Yes,
these are the
rightly,
two
clearly on the
points I
basis
have
of-
drawn up, Your Lordship. Now I am coming to merit. Here, the Exhibit 1 is the voter list of 1966, page 23. This the name of Alimuddin Sheikh and Abdul Sheikh. So these are the, now let me go to page 5. The petitioner expressed that his father had shifted from village Shuapata to village Kazaikata Part 3, PS Birashipara, District Gwalpara, now Dhubri Assam in the voter list of 1970. His father's name has been recorded as Babur Ali Sheikh, son of Abdul Sheikh. Now, this page 23, Abdul Sheikh is his grandfather. And his father's name has been recorded in the voter list of 1970, that is page 15. Babur Ali Sheikh, Abdul Sheikh. Now, NRC details, page 17. Of course, that is not exhibited. Thereafter, Lordship would see Annexure 166 voter list in the name of his grandfather, then Annexure 2, Exhibit 2 is the voter list of his father. Now, Exhibit 6. Exhibit 6 is the Panchayat election voter list, page 21. Actually, the proceeding. Then Exhibit 4 is the Gauhati certificate. Here in this requisition, we have not annexed, but in the LCR, it is there. Exhibit 4 is the Gauhati certificate. Now, Gauhati was thought to be adduced his evidence, but that was not allowed by the learned tribunal. Now, Lordship, kindly see page 7, para 7 of my requisition. After 5 lines, or I am reading from the first para 7. The petitioner wishes that in spite of all aforesaid documents in respect of his citizenship, notice was issued to him alleging him to be a foreigner of 1966-71 stream, but declared him as foreigner of post-1971. He submitted his written statement and evidences in respect of his citizenship. On the other hand, he could adduce evidence of Gauhati and other persons, but the learned tribunal did not allow him to adduce any evidence which is his common practice. In this regard, there was protest among the lawyers of Bangaldoi, which has been also published in different papers, including Assamese Proceeding Sangad newspaper. So, this Gaura is Sri Bangshidhar Deka, page 49. It is written by the tribunal, page 49, para 10. During the course of evidence, the Gaura Sri Bangshidhar Deka of Jabari Kuchi village, PS Mangaldoi district, Dorang, annexary issued a residential certificate dated 34/18, and the office name is Hashu Ali, son of Babur Ali, and he, Gaura, knows the Opi and her father, Babur Ali. From the residential certificate, it is clear that Opi had failed to establish his existence before 25/3/71 and no help to prove the existence of his parents from the cutoff date 25/3/71. So it is the wrong finding of the tribunal that he could not prove that his existence is there before 71, because at that time my father was there. My father's name is recorded in the voter list of 1970. So at that time I was not qualified to become the voter. So it does not mean that my existence was not there. So this finding is also not acceptable. But later on, my names are there in the voter list. Then, my lord, there are some anomalies in the names of father as well as the proceedings, whose clarification I have given in page 6, para 6. And in this regard, I have also annexed the judgment of Sirajul Haq, that is page 26. Then my last submission, Lordship may kindly see page 44. Appearance, advocate for the opposite party, Shohrani, and advocate for the government, none. So there was no government advocate, but pros is there. Kindly see page 36. This is the cross. Now, question is this. When there is no lawyer from the government side, who had done the cross-examination? Definitely it was done by tribunal. So tribunal, in other words, if we say that tribunal is interested very much, then perhaps I would be not in wrong. So on the basis of all these points, my humble prayer is this: the impugned order of the landed tribunal should be set aside and I should be declared as Indian citizen, or otherwise, as I was not given to adduce evidence, so case may be remanded. But that is my second and alternative prayer. First prayer is that order suffers from various illegalities, which this Honorable High Court under 226 may interfere. Now, my Lord,
Allow you to adduce a witness. That is perhaps not correct. That was never the case before the tribunal. You, in course of the proceedings, you have filed two petitions stating that you want to examine someone as DW2, but you don't even give that name. And the tribunal refused that, examined, and then closed the matter. So your submission that you did not get an opportunity is perhaps not correct. That's
then
one.
maybe, but it is also circulated in different papers also.
Oh, in paper, you can
There
write
are-
many things. After you go out of this room, you can say that
No.
Justice Surana.
There are lawyers
heard you.
protest also. And matter went up
No,
to
no.
the Supreme Court.
But that we don't have a control. We can't stop you from making a UN cry outside that you have not been heard. Only
However,
those
I
only
leave
those
it to
who are
your lordship's
excited can,
consideration.
know that you got a full opportunity. If you shout outside,
My lord,
nobody will know.
my lords are well versed in this type of cases. The
No.
quality of
that's-
evidence is preponderance and probability.
That's on part of the, you can't justify that. Merely
In
because
Abdul
somebody has
Rahim's
written
case,
into it.
the Honorable Supreme Court has discussed very vividly about the pros and cons of such type of cases.
We don't know about
So,
that unless you show us this judgment, we don't know anything.
uh,
And Mr. Pang, on this ground itself, it has to go, because the cross-examination is by the court. The presence of, in the opinion, if none is present. And even in this record, the government advocate is not there. It couldn't have been cross-examination. That vitiates the order. You can have the record. Presence of government advocate is not there. order dated 5/7/2018. This presence is not there.
It's clear, my lord, that this part of the, my lord, which my learned friend is saying that this cross part, this was not considered, my lord. This was not considered. While my lord, this can be treated as, my lord, instead of cross-examination, my lord, it can be treated as, my lord, clarification under 165. That, my lord, so otherwise, my lord, the opinion was, in the opinion, the tribunal has not considered that part of the. It is clear, madam, it is, there is no presence of AGP. It is clear, madam. Yes, but,
My lord, excuse me, may I go to our court? My junior would be here. My lord. Pardon, please, I don't, could not finish.
You see, you made a submission that the witness, they was not allowed to bring the compromised witness. That is not there on record. So if
I was
you,
doing no problem.
huh?
I was doing that
So then don't say anything.
because there was protest, etc. etc. So on that basis.
That
I
everybody can have a right.
took-
Everybody has a right.
I'm going to another
for
court.
responding.
madam, with regard to reference, if your lordship is not mentioning, then I am not arguing. With regard to reference part, I'm not arguing, madam. Not necessary. Only from the, madam, the cross part.
By filing the petition under Article 226 of the Constitution of India, the petitioner, namely so and so, has essayed the opinion dated 24/7/2018, page 43, passed by so and so and so and so, by declaring the petitioner to be a foreigner of 1971 stream. Next paragraph. In view of the nature of order proposed to be passed, comma, there is no necessity to discuss the pleadings and evidence on record. It would suffice to mention that the petitioner examined only himself as DW1 and had exhibited 7 documents which were marked as Exhibit 1 to Exhibit 7 respectively. However, out of this set, on Exhibit 5 document, Exhibit 5 documents which are marked as Exhibit 1 to Exhibit 1, Exhibit 2, Exhibit 4, Exhibit 5, Exhibit 6, and Exhibit 7. The out of which 2 documents out of the Our a photocopy of the NRC legacy data was not marked as exhibit, but was referred to as Annexure C, and there's a Gampura certificate on record, which is marked as Annexure 5. Next one. On a perusal of the records, it is noted that on which I can tell you, around on 5/7/2000. On the petitioner was present before the learned tribunal, and the learned tribunal recorded cross-examination of the petitioner, Mohammad Hasu Ali, as DW1. Full stop. However, the tribunal's record do not disclose presence of the government advocate for the purpose of cross-examination. Full stop. Moreover, in the impugn opinion, the government advocate representing the state is stated as inverted commas, none. Next one. Therefore, the court is of the constituted opinion that if the cross-examination was not conducted by the government leader of the government advocate, the tribunal had power to ask questions which would be referable to powers under section 165 of the Evidence Act, 1872. But the tribunal would have no authority to cross-examine the witness present. Accordingly, the court is of the considered opinion that the recording of the cross-examination of petitioner as DW1 by the learned tribunal has vitiated the entire proceedings. Next. The learned standing counsel for the FT and border matters has made his submissions to support the opinion by submitting that the cross-examination of the DW1 was not discussed in the impugn opinion, and therefore it was submitted that the same would not prejudice the petitioner. Next, be that as it may, and the considered opinion of the court is not for the tribunal to conduct cross-examination of the witnesses present, and therefore the cross-examination of the DW1, instead of being recorded as a court question, is found to appreciate the entire proceedings. Next, accordingly, the court is inclined to expunge the cross-examination of DW1, which was conducted by the learned tribunal on 5/7/2018. Resultantly, the impugn opinion dated 24/7/2018, page 43 is also set aside. Next. The matter is remanded back to the said learned tribunal for being taken up at the stage of examination of DW1 either by the learned tribunal under section 168 of the Bharatiya Sakshya Adhiniyam, not 168. In the by the learned tribunal. So, however, the state, but the government advocate representing the state would have a right to cross-examination the DW1. Thereafter, the learned tribunal can pass a fresh opinion on the basis of materials available on record. Next part. The petitioner, was duly represented by his learned counsel. Petitioner, namely, directed to appear before the learned member, foreigners, travelers, and so on 6/5/2020, on or before 6/5/2026, and by producing a certified copy of the order.
So I pass.
And shall be ready for his cross-examination and or examination by the learned tribunal, as the case may be. Next, in the event the petitioner fails to appear before the said learned tribunal on the date fixed, on the outer date fixed, it will be open to the learned tribunal to treat the petitioner as absent on call and pass an appropriate order as it may be deemed fit and proper.
Only one line, my lord.
The registry shall send back the tribunal's records expeditiously, along with a copy of the order to be made a part of the record. Yes.
No further evidence.
So you said from that stage only.
Item 3.
Just one. Please be here. the learned, kindly goes for your home and, for the Asian border matters, and transmit a copy of this order to the Home and Political within the P department, so as to enable the authorities in the said department to circulate the copy of this order to all the foreigners tribunals to bring it to their respective notice that in the event the government advocate is not present, not open to the foreigners tribunals to cross-examine, but the tribunals put their power under Section 168 of the PNS 2023 put questions as deemed appropriate. Yes.
Item 3.
May I please understand? Members, here in this case, the petitioners have declared to foreigners of 1970 after 1971 members. On the ground that he cannot establish his linkage with his parents' matters. Judgment is 29, page 29, middle of the judgment, middle of the days after hearing. I have found that the opposite party has miserably failed to prove his statutory burdens under Section 9 of the Foreigners Act 1946 to establish his linkage to his parentage matters. In the grounds matter that he cannot establish the linkage. As in this matter, the petitioners submit numbers of the documents in this case. First, I came to the voter list of 1917 page 50-51 matters. 1970 voter list. Petitioner's name is Ananta Kumar Rai, Ananta Mandal, and father's name is Hemanta Mandal. Petitioner's page 50-51. Petitioner's father's name appears in the voter list of 1970. Hemanta Mandal and Nitya Hari is the grandfathers of the petitioners. Second, page 52 and 53 matters. In the NRC of the petitioner's fathers, Hemanta Mandal, 1970 NRC. 52 and 56 and 53 matters. 1970, his father's name appears in the NRC also. And next matters 54 and 55 matters, type copy and original. His father's name appears in 1979 voter list as the Hemanta Mandal, grandfather's Mr. Hari Mandal. 1985 voter list, page 56 and 57 father. Father's name Hemanta Mandal and Mr. Hari grandfather. 1985 voter list matter. Next comes to the petitioner's name appears in the voter list in page 58 and 59. Dates and 59. Petitioner's name Hemanta Mandal and his father's name is Ananta Mandal, petitioner's name, and father's name is Hemanta. 58 and 59. Voter page matters, voter list 1993 matters. Petitioner's name appears in the voter list along with his fathers. Next matters 60 and 61. Here's matters the petitioner's name appears in 1997 voter list Ananta Mandal. Here's matters the wrongly his father's name is written as the Nitai. Nitai is the grandfather of the petitioners, my lord, which I have elaborately discussed in the written statement.
Although I know a little about the surnames used in Bengali or Bengal, we should say, is surname Roy interchangeable with Mandal?
Mandal, my lord.
Is it interchangeable?
Sometimes it is changed as a Rai.
No, that's okay. Rai, Roy, anything.
No.
Roy, Rai, Ray, anything. Is it interchangeable with Mandal? Is it permissible historically?
And my lord, they have not changed the surname, my lord. Mandal is Nitai Ananta Mandal.
I'm not an authority on surname, but Roy we understand is normally a Brahmin. Mandal, we know from Mandal Commission case that this is not considered as a forward community. So is it interchangeable in the caste system prevailing at that point of time?
That's why I don't know, my lord, whether it can sense or not.
So because if it's not
Mandal-
wrong to use.
Mandals and can use in the community also.
I don't know. I'm not a authority. I'm
And
just asking
Muslim
you a question.
community also
Huh?
written, Muslim community also written as
No,
Mandal.
I'm not on that. I'm not on the other community. He's perhaps not a Mohammedan person.
Not Muhammad.
So we are confining it to be a Hindu. In Hindu is Roy and Mandal interchangeable. You don't think so? Because Mandal Commission
Fine, fine. Muslim community Mandal like that.
okay, yes.
My lord, similarly, he has submits the voter list of voter list of 2005, 2010, and 2017, my lord, along with his father's name, my lord. Page 62, 67, my lord. Thus, he has, by filing this voter list, he has established that he established the linkage with his fathers, that the Hemanta is the fathers of the petitioners. Now, this voter list has verified by the page 68, my lord. Verified by the verified by the election officers, my lord. 68. With reference to subject cited source, I have the honor to say that the certified copy of the electoral rolls for the years 1970, 1979, and 1985 in respects of the Hemant Mandal, father of the petitioner, Nitahari Village, Swansea, LSC, Swansea, house numbers, Swansea, have been examined through the records and found genuine. He has given the certificates that these documents are genuine documents, and it was proved from the original. Similarly, petitioners page 69, 70, he has filed a voter identity cards along with his father. 70, 71, 72, PAN card also submits along with his father's name. And page 73, Lakmandal has given a certificate that the Hemanta's name is found in, father's name is found in 1970 voter list, and petitioner name is found in 1993 voter list in house number 1 and 4. This given the Lakmandal has given the certificate. Thus now the petitioner established his linkage with his fathers. That's his father is the Hemanta, and by submitting the voter list of 1970.
Which
And-
page is that document, election officer? Where is that page?
It's 73. The
Page number?
page 70, the Lakmandal has given a certificate.
Page number?
Page 73,
73.
73, 74.
No, not this. The earlier one you showed us. Election officer.
Election official page 70,
70.
page 68. Verified from the records and found genuine. By submitting number of
Please show the voters list again. In 70, 79, 85, 1993, please show us again.
Voter list. Page 50, 51 to the voter list. His father's name. Hemant Mandal.
In 70,
Page 50, 50, 51. 1970 voter list.
this is exhibit 1.
Exhibit 1. Exhibit E. Here this petition, the annexer E. Exhibit, I think exhibit 1. Exhibit 1. Exhibit 1. As the exhibit list is given in page 26 of the judgment. Exhibit, this is the certificate of the voter list 1970, 79. Page 26 is the exhibit list is given by the clearly given. All the voter list. Exhibit E is the voter list 1997. Hello?
How are you connecting to to your father? By which document you are connecting? Only the voters list.
Voter list. Yes.
But voters list, there is a change in the village. How do you
Change-
relate it back?
Madam, previously it was in Buxar district, Abhayabari village. Buxar district, and 1990, he has shifted the village due to his livelihoods. Petitioner shifted village 1990 in Nauldoba village under Boko police station. In the petition, I have written page 10, paragraph 9. Written statement also written. Shifted. Page 33, paragraph 11 also written.
In between 85 and 1993, there's a disruption of your link. Hemanta Mondal is a voter of 1985, but village is Ahiyabari.
Yes, my lord. In Buxar
Yeah.
district,
No, whatever the,
in 1990, he has shifted. Petitioner shifted
no, but then you
from
see,
Buxar to,
but that's okay. We are not questioning it now. But your exhibit D is the voters list of 1993. Here's the Ananta Mondal, son of Hemanta Mondal, is a resident of Ahibari, Neul Doba. This another voters of Tilali, Dodgio Madhusuda. We don't find him connected to you or your parents. You have not explained why his name was there.
nineteen 1993 voter list is Kamrup district, my lord, Boko police station. Is 58, my lord. 93.
Yes. And after the name change comes.
After
Roy,
the
he
name
became
change,
Roy
his name came.
in 2010.
Due to poverty, he has uh, uh, he has worked from one place to another place, so he could not properly appears in the hearings matters. So his name is not appears in the voter list period to 1993. Due to livelihoods, he has changed the place.
Take a break and yes.
After submitting all the voter list along with his father's petitioner established the linkage with his father's matters, and he has proved the case, and he is from Genian's father, whose name is appears in 1970 voter list and NRC also. So he is a citizen of India. He may kindly be declared as a citizen of India. He has not come after 71. He has not established the linkage. It is filed.
Okay.
Okay, again, I have to-
Which is the voter list where your name appears first for the first time?
1993.
1993, first time his name appears. Thereafter 1997, his name is also appears, where his father's name is shown, is not shown, his grandfather name is shown instead of father's. The clerical mistake. And subsequently, 2000. Subsequent voter list 2005, 10, and 17. His name appears along with his father. And he has established the linkage.
Okay. Yes.
Well, the present petitioner is
Just come.
the reference again, the reference of this case, Madam, the reference is mainly one Madam against Ananta Kumar Roy. But the petitioner has Madam in his evidence as well as in WS has said Ananta Kumar Roy and Ananta Mandal is same in one person. Apart from that statement, there is no proof that Ananta Mandal and Ananta Roy is Madam same in one person. That is their Madam. So the reference was against Ananta Kumar Roy, Madam. But the entire document, even though he has mentioned in some documents his name has been mentioned as Ananta Mandal, Ananta Roy, but he has not proved any documents to show that Ananta Roy and Ananta Mandal is same in one person. However, he has admitted, Madam, he has written page 41, Madam, there is a statement in evidence.
Last paragraph.
Yes. Now, page 41, that is the statement, my lord. Page 41 in WS, last para, my lord. That father's name recorded in the voter list of Hemanto Mandal, Hemanto and Nitai. All the name are same in one person having single identity. That is my father, and my name has been recorded in the voter list and other records as Ananto Mandal and Ananto Kumar Roy. All the name are one and same person having single identity. This is the only statement with regard to the my lord, same in one person. Even though we ignore that part, my lord, the tribunal has come to a finding, my lord, there is no link. That is true. That is evident from the record, my lord, because if your lordship may kindly see, the petitioner, my lord, while filing this writ petition in affidavit, he has declared his age as 61 years, my lord, page 22. And this is, my lord, corroborates the 1993 voter list, my lord. 1993 voter list, it says he was 36 years in 1993. So date of birth will be sometime in 1958, my lord, the petitions. And he was eligible to cast vote in, my lord, 1979 itself. At that time, it was 21 years. So 1971, he was eligible to cast vote. And it is, my lord, submitted as well as, my lord, in the WS and evidence, it is stated that, my lord, he shifted from the original village, to present village in 1990. Now in, my lord, if your lordship may kindly see the voter list of 1985, page 57. It is in the Ahiabari, where according to petitioner, he was born. And in 1985, he was eligible to cast vote. And it is admitted by him, he shifted to present village, my lord, it is, my lord, the Kahibari or Neulduba in 1990. So 1985, his name should have been there along with his father. Even in 1979, page 55, the voter list of 1979, there also his name should have been there, along with the father, Hemanto Mandal, projected father. 1985 also, my lord, his name is not there. It should have been there if he is the same person. Now his name is appearing first time in a different village in 1993 at Kahibari, Neulduba, at page, my lord, 59. At the age of 36 years. That's why my lord, the tribunal has also said he has failed to link himself to his father, projected father. Had there been a common voter list where the, my lord, both the names appear together, that could have been the, my lord, the proof. But in absence of that, and the Gauvura, my lord, Gauvura has also not stated, my lord, he has shifted from that village. Gauvura certificate is page 74, particular. He has simply said that Ananto Mandal is the son of Hemanto Mandal of Neulduba village, and he belongs to the Masudra community. And page 74, my lord. This is the Gauvura certificate. He has simply said that Ananto Mandal is son of Hemanto Mandal of Neulduba village and belong to Namasudra community. And his name is and he has stated, my lord, he has seen the same voter list of 1970. According to 1970 voter list, one Hemanta Mondal is a voter at Tamulpur constituency, and Ananta Mondal is a resident of Kamrup district, Gauhati, Boku, and voter in 1993. That's much. And to link, the petitioner could not establish his link to the projected father, Ananta Mondal, Hemanta Mondal, or even in WS in evidence, he has not stated, my lord, the mother's name, if any siblings are there. Had there been, my lord, other names and mentioned in the WS as well as evidence, and my lord, appeared in the voter list, and if we could compare, my lord, all those along with the petitioner, then it could establish that he is the my lord, son of Hemanta Mondal. In absence of linking documents, my lord, because this is a single voter list. 1985 is a single voter list where the petitioner name is not appearing. This is the crucial document, my lord. 1985, he admitted he shifted to present village in 1990. Why his name is not there in 1985 along with his parents in the original village?
Due to livelihood and she.
No, that's why, my lord. Even in 1979, his name is not there. His name should have been there in 1979. But 1993, in a different village, first time appeared. In 93 is not in the same village. It is in a different village. So my submission is that, my lord, in fact, in 1993, one Dilali is there. My lord, that's why I'm saying, my lord, the had in voter list consisted of the others' name of the family members. It could have been better, my lord. Then the petitioner could have established, yes, this same set of persons are along with me in 1985, was along with were along with the father in 1985, and same persons who are also in the voter list of 1993 along with me. Then it could have been a different case. But in 1993, one Dilali is shown to be listed along with my lord, the petitioner, who is the wife of Madhukar. This is 1993. So who is this Dilali? It is not known to us. It's not explained. And why the parents' mother name is not there? Whether there is any sibling, those are not displayed. Either in the WS, nor in the mandate evidence. So it seems, my lord, the petitioners first came to India only in 1993. That means his existence in India is only from 1993. So if you want to get benefit of CA, my lord, to 2019, then he can definitely get the benefit of CA. But it's not, my lord.
My lord, in the Gaubra cross examinations, it is clear. Page 48, my lord. I'm the government, Gaubra and alia and evidence. 1970.
Two voters list. 1917, where is this?
One
Is
is
1970 and 1993.
yes, my lord.
From 1993, he is not a mandal of that village. What we call Ahia Bari.
Yes, my lord.
He is a Gaupura of a different village.
Now, where the petitioner,
Hauditari and
where the petitioner shifted,
no, but he
that's
is
Gaupura is
certificate
given.
about the birth. How can this Gaupura know about the birth of this person?
They verified the voter list.
So
Yeah.
voter list, you don't get the name of the
Verified
children.
the voter list of 1917, 1993.
There you don't have the data that the petitioner was born there. So he is exceeding jurisdiction. He is looking at different voters list and giving certificate.
He has already given his statements in written statements and deposition. That's duties, livelihoods he has shifted in 1990 in another place. And that's Boko police station, where his name appears in 1993 in voter list matters. And due to the poverty and livelihoods, he cannot appears the time to times, even the hearing is to enter his names in the voter list. He could not given the hearing due to illiteracy and his livelihoods.
But it's HA Sarkar and transfer for the petitioner and transfer for the respondent. This is for delivery of this forms. 8/4/2026 for delivery of orders.
Item 4.
Made visual of it. My lord, petitioner before your lordship, my lord, has assailed the opinion, my lord, dated 21/12/2018, my lord, at page 63, my lord.
Where is your written statement?
My lord, written statement, your lordship will find, my lord, at page 52, my lord.
52.
Yes, my lord.
Where have you stated about your family here? Have you
My
disclosed
lord,
the names of your family members?
names were not only, my lord, uh, uh, as a parents, my lord, here, written here, my lord, stated here, my lord.
Name of uncle is not disclosed.
My lord,
Name of uncle is not disclosed in the written statement.
my lord,
DW2 was your uncle.
yes, my lord.
No, uncle is not DW2. Uncle is,
DW. DW2 is a, my lord, Gagura, man.
uncle is page 60.
Yes, sir.
No, not 60. No, his name is also DW2. Come to page 62, he is DW2.
62.
Mr. Payang, you both of the records. There are two DW2s. One is a Gauhati. And again, there is another witness, PW2, which is at page 61.
Abed Ali, man. Abed Ali is the uncle, my lord.
No, page 62. Abid Ali, this is OPW2. In the top, you will find.
Yes, man.
Correct? You've seen that in the top.
OPW2.
Yes. Now, if you look at
OPW2, Abed Ali.
the Gauhati is also DW2.
Page 61. The page 61 is my lord DW3, OPW3.
Ah, yes. See. Yes, yes.
Hamid Hussain. Hamidan Bibi is her mother. My lord, here the petitioner's own name, my lord, was recorded along with her father, my lord, page 33, my lord, total list of 1997, my lord. Page 33, my lord. Sabed Ali Amidan is her mother, Saiful is brother, and Fazila. My lord, total list of 1997, my lord, page 33. Honorable Loss of Finance, page 34. Because exhibited as exhibit 4. And another document, my lord, the loss will find at page 35, my lord, is a matriculation admit card, my lord. Exhibit 8, my lord. My lord.
Taken up today, this from. Just after we get.
Thank you.
Twenty. 21st will be.
21st April. For the other matters.
My lord.
Item 5.
Okay. Both sides are represented on the prayer made by land counsel to the petitioner, the matter stands adjourned today. This round. Yes, after.
21st.
May it please your lordship, I am appearing for item number 6 on behalf of my senior Sabir Ahmed, who is out of session for some medical emergency. Lordship may kindly fix any other date.
Mr. Aheng, in this case, there is a document which is exhibited, Jamabandi. It's not discussed. Second is the deposition of DW2, purported brother. That is also not discussed. Come to page 35,
No, I'm sorry, my lord, I don't have.
you don't have the. Exhibit 5 is the Jamabandi copy.
Yes, ma'am.
Exhibit 6 is Gauhati certificate.
Those are not discussed, ma'am.
These are not referred in the order and neither discussed. Then there is DW2 one Oliur Rahman was examined.
But not discussed. Oliul Rahman, ma'am.
Yes.
Yes.
These evidence is not discussed.
Yes.
And this exhibit 5 and 6 are not referred to.
Five is Jamabandi,
Jamabandi.
Yep.
And
Six
6
is
is
certificate.
certificate.
Consider all this, my lord, you not the demand it. Fixing it.
You see the opinion?
Yes.
17/5/2019. You turn over to the page number 2
Yes.
of the opinion,
Exhibit
exhibit 1, 2, 3, 4.
3, 4, 5. 5 and 6 exhibit Mala para 2. Exhibit 6 is a copy of the revenue charted for revenue police. Along with other family members that purchased in 2018. Exhibit 6 is the residential certificate. However, none appears before the tribunal to prove the aforesaid exhibits as required under the law.
You're reading the opinion.
Yes, ma'am. Opinion para 2, next page, second page 2, ma'am. And the second page, second para. My lord. 3 close 1 and close 2, there are 2 close.
3, 1 and 2.
Yes, 2 is exhibit 5 and 6.
Please send it back. There's some discrepancy then. This is not the, it's not there in the writ petition.
This is the opinion dated 17/5/2019, ma'am.
Opinion is 17/5/19.
Yes.
Case number 1488 of 2018.
1488 of 2018.
Just send it. No. It doesn't match with the certified copy. Certified copies, you have flagged it, doesn't match. Please examine and tell us, we'll take it up on Friday then.
Yes, some other thing.
No, not Friday, day after tomorrow, Thursday.
My lord, let the petitioner,
You can keep a second copy, you can keep it.
no, but whether, my lord, the only part, let it be on table.
You can keep the second just copy with you.
Yes, yes. As well as this record, man.
Both sides are represented. There appears a mismatch between the certified copy and the copy of opinion, which is available in the travelers record. Accordingly, the travelers records as well as the second second court record is handed over to the Mr. J. Pang and its chronicles for the FT and bottom matter for his perusal and purchase report. Next is Tom. Second April.
Item 7.
May I please, Your Lordship? Your Lordship, the engaged counsel in this case is out of station. So it may be taken up after due vacation. It may be adjourned today. Leave notice there, Your Lordship, in the cause list.
Both sides are presented on the prayer made by learned counsel for the petitioner. The matter stands adjourned today. List on. We take up to the
21st April.
List.
Item 8.
May I please? In this case, Lordship, arising out of Vasishtha PS case number 6426, Lordship, under section 319(2), 304, 5A BNS, with imprisonment up to 7 years. The investigation officer and his team has illegally searched my house. So FIR Annexer A, case number 16. Arising out of the said case, Lordship, after 10 days after lodging the FIR, that is on 22/2/2026, the police personnel has suddenly entered into my houses without the assistance of the concerned police station. FIR case number 16.
Case number,
16.
not matching with me. Case number not matching.
which page?
Page number 16, not matching with me.
Which page number?
16, 16.
16.
FIR, he said FIR. But it's in my petition 22.
Both sides are represented. Mr. R. Borogora, and government advocate submits that the page 16, which is a copy of FIR, as urged by the learned counsel of the petitioner, is not matching with the copy served on her. Accordingly, the matter stands adjourned today. Mr. N. M. Sekhar and counsel for the petitioner shall provide correct copy of the correct service copy to the learned government advocate in course of the day. Next list again on 6, 4th and 26.
Give to list.
Item 9.
May I please, your Lordship? Lordship, kindly matter will be adjourned for a day, Lordship. The engaged counsel held is unwell, Lordship.
Mr. Pai and Mr. Sharma, we are issuing the same order, whereabouts? Your name?
D. Datta, Lordship.
D.
Datta.
What is Datta?
Yes, Lord.
That means D. Datta on the petitioner and transfer for the respondents. Next order. Filing this habeas corpus petition under Article 226 of the Constitution of India. The petitioner projects that her husband was declared to be a foreigner by opinion dated 29, ex parte opinion dated 29/3/2017, passed by the learned member, foreigners tribunal, Hailakandi, in FT case number 14 of 2016. The petitioner sought for a review sought for a review before the said learned tribunal, which was dismissed. Because of the petitioner unsuccessfully assailed the said opinion before this court, but WBC 3965 of 2025 was also dismissed by order dated 21/7/2025. The orders were unsuccessfully challenged before the Supreme Court of India, which was being SLP within packet C, packet was number 28272 of 2025, which was also dismissed by order dated 15/10/2025. Next is projected that on 6/2/2026, the husband of the petitioner had left the house, but did not return, and subsequently she came to know that the police personnel from Katlichera, Aatlicherra police station, had taken the petitioner into custody, the husband of the petitioner into custody. Mr. Howard, she is not informed of the whereabouts. That's why it is also projected that on an earlier occasion, the petitioner had approached this court by filing WB criminal number 13 of 2026, but same was withdrawn as necessary parties were not included. White order dated 18/3/2026. Accordingly, the present petition has been filed. Next. The we request the learned standing counsel for border and FT matters to ascertain the whereabouts of he declared foreign national, namely Islamuddin Laskar. And inform the court. Look, take up the last photo. No. Of the learned counsel for the petitioner shall provide a hard copy of the lead petition along with a soft copy thereof to the learned standing counsel for border and FT matters to enable him to obtain instruction. Next, the learned standing counsel for the FT and border matters shall send a downloaded copy of this order to the Home and Political Secretary at those department to enable him to obtain instructions. Next, list on. You'll have to give him by tomorrow. Yes, then.
My lord, what happened, problem is that, my lord, my name is not shown here. In fact, I was not soft copy in this.
That's okay. I'll give you a copy.
Port, you can get probably. Whereabout, my lord, I can get it by port,
Fourth.
if your lordship is sitting.
Fourth is Saturday.
Yes, ma'am.
Okay.
If your lordship is sitting on, otherwise, can it be on Monday? Let it be on Monday, ma'am.
6. 4/26. But giving copies.
And my name may be there. FT standing counsel for FT may be shown, otherwise I will be set up.
Just before that instead. It may be recorded that the learned standing counsel for the border and FT matters has submitted that he was not served with an advance copy of the red petition. And his name is not reflected in the cause list. Next, accordingly. The name of the SC, FT and border matters be reflected in the cause list in respect of respondent numbers. Oh, again, your repetition is defective. You don't know how to write the nomenclature of respondents. Again, we can't issue notice. You have to correct it. You see what you have done. Respondent number 1 is Union of India represented by Assistant Solicitor General of India. You don't make Solicitor General of India a party. Why do you complicate things? Earlier was withdrawn because there was no, the proper party was not there. Again, this will have to be deferred till you impede. For response.
3 and 4, ma'am.
2 to 5.
3 and 2, 3, 4 and 5.
When you say it also appears that the cost title in respect of respondent number 1 is defective, but the petitioner shall file an interlocutory application for correction of the cost title of respondent number 1 in the being corrected. In which the name of respondent number 1 will be struck off as the Union of India is represented in the because that the Union of India is represented by the Assistant Solicitor General of India, is can't be sued in the name of the Union of India. Next, this one. By that time, sixth, you better file an application, otherwise this name one will be struck off.
Item number 23 may be taken up on Monday, my lord.
Just a moment. Item 10,
I will.
yes, item 10,
Item 10.
no resolution from the expert. This one. Sixth. 11,
May I please your lordship? Contested matter, MP and order dated 25/4/2025,
page,
page 88.
'88. Mr.
F.A. Ahmed.
S.A. Ahmed, and counsel for the petitioner, and so for the respondents. Opinion dated page 88. It is 25/4/2025, passed by so-and-so in case number so-and-so, old case number so-and-so, police inquiry number so-and-so, by which the petitioner were declared to be a foreigner post 25/3/1971. Notice extra copies within 2 days, call for the report. Prayer for bail is opposed by the learned standing officer of the European Court of Appeal. Considering the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Order, Silsagar.
Soraydem.
Sorry,
Soraydem.
make it Sorry. But if in order is by, the reference is by,
My lord, if it was, my lord, prior to the division of the district.
it will come there,
then
record will
it
come
will come
to
to the
just after 4 weeks.
Item 12.
Obliged.
Yes, 12. Same on the case. This one.
Upgraded item 43.
Yes,
What's it? What's it? What's it actually the conducting council is?
opposite time.
What's it?
44.
Sorry, my lord, I'm appearing for item number 43, my lord.
Just wait,
Yes, my lord.
we're called 44. 44,
Item 44.
this is here for extension of time, Mr. Pang,
Yes,
but the order is of 2020.
yes, madam. And it is filed in 2025.
The now appears on call for the applicant, or into justice matters and return today, list on 6th. Forty-five.
May I plead your lordship? Lordship, an application for, my lord, fixing an amendment dated appearance of this petitioner's, my lord, concerned tribunal, my lord. Order is, my lord, annexure 1, page 7, my lord.
Yes,
Yes, my lord, after passing this order, my lord, try to communicate this petitioner's, my lord, but she has not on mobile phones, my lord. That's why, my lord, she is not appear before this tribunal, my lord, concerned date, my lord. Another date may be fixed, my lord.
no, from after 23, you have come after 3 years.
My lord, this IR file, my lord, 26/5/25, my
You
lord.
should notice you respond to it. You respond to this,
Yes.
and also find out what has happened in the tribunal.
I will respond it.
Take it up on 22nd April. File a response.
Oblige, your lord.
Heard Ms. Al Wazir and counsel for the applicant.
Aye.
And so and so for the response. Next. If you notice on this interlocutory application, it is made returnable on 22/4/2026. Objection, if any, by the respondents, be filed prior to the next date of listing, list of 22/4/2026.
Oblige, your lord.
46.
None. Same none. Just as matter stands returned today, list on. 48. 48.
48.
Yes.
Save the lordship. Lordship, the eyes for continuation of delay, lordship, is a delay of 190 days, lordship. So assailing the learned single judge order also already there is a read appeal, where lordship has already lordship condoned the delay. There lordship, may I be allowed to place that order, lordship?
Yes, any objection to the conditional delay? Allow the application?
On 11th. May I place this one? I'm sorry, lordship, I'm having only one copy. 11. No, 11. Only difference is, lordship, number of days, lordship. Here it was 65, here 119 days. Rest are same, lordship.
Level 2 education, who is there?
As for, I will inform her, lordship. As
We'll
for,
list it on Monday because we are not passing orders in their absence.
Lord.
Uh, Mr. A. Dekal and counsel for the applicant is present. Applicant and Miss, what's your name? Ms. Koilari, standing counsel for PTC is present. All the other respondents are unrepresented. This is a matter stands returned today, this on Monday, 6th.
Blank.
Was the
Lord,
copy in
yes,
Yes, 44, what do you have to say? Which item was yours?
43, madam.
In this case, there is a pending IA, my lord. We have, in that time, we have filed this IA. So, taking a direction to the officer in charge of in police station for lifting the or relaxing the condition of regular appearance. So that after getting the interim order, we have appeared before the superintendent of police Nagaon border. He verbally asked us to appear before the officer in charge of in police station. And after complying all the formalities, there is no order that we have to appear on April 15th. But he was at that time he was insisting that we have to appear on April 15th.
So fine, we remove that condition. Your name?
Please, Chakraborty.
But please Chakraborty, now talk for the applicant and principal for the respondents. Next. By filing this interlocutory application from the applicant is seeking exemption from appearing before the officer in charge of Dhing police station every 15 days. Next, it is stated that this court by order dated 26/4/2019 passed in WBC 26/2019 while granting bail had granted 15 days time from the date of the order to furnish bail bond. So, however, without any direction of this court or the officer in charge of Dhing police station is requiring appearance of the after every 15 days. Mr. Fine, this order to be by SP, bail was to be by the SP. Why this Dhing police station has come in between?
Well, only the foreigners in each and every police station, there is a foreigner office, man. Direction may be made to the SP only, man.
It should be by SP only.
Yes.
Look at statement made in paragraph 5. It says that he went to SP. SP this says go to Dhing police station.
The SP, madam, bail bond they have submitted before the SP.
No,
Bail bond has to be submitted before the SP.
no. Right. See paragraph 5. Into SP, but
It normally bail bond accepted by the SP, madam. I have
direct him to appear before the SP again.
yes,
Because this will be a proper.
yes,
Means High Court says
yes, yes,
SP.
yes. We directed to appear before the SP. Honest bail bond, madam.
Also posited that as per the order of this court, the applicant had appeared before the Superintendent of Police order Nagaon, but he was directed to appear before the officer in charge of Dhing police station and submit bail bond. Next. In this regard, the court is of the considered opinion that as this court by order dated 26/4/2019 passed in WPC 26/2 of 2019 had directed the petitioner to the applicant to appear before the Superintendent of Police order of Nagaon. We once again direct the petitioner to appear before the Superintendent of Police within bracket order, Nagaon. It was 15 days from the date of the order and produce a certified copy of this order. Next, on production of a certified copy of the order by the Superintendent of Police, order Nagaon. Within bracket, respondent number 5 shall satisfy interpret to the as to whether bail bond the SP and take bail as directed by order dated 26/4/2019. On appearance of the petitioner or the Superintendent of Police shall have two conditions, that iris of the eyes and off that will be recorded. Next, on bail bond being accepted by the Superintendent of Police order Nagaon, he shall the said authority shall do the needful for discharge of the bail bond which is stated to have been executed before the officer in charge of being police station. Next, as this court had not directed the petitioner to the applicant to appear for the officer in charge of being police station every 15 days from a set condition would not be insisted upon by the Superintendent of Police order Nagaon. Inappropriate appeal stands disposed of. In terms as indicated above. Three, maybe taken up on Monday, madam. 6. Then on 8, minor. 7, 7, 8, minor. Mm-hmm. 23, my lord, item number 23.